Plaintiff's name meaning for the husband and wife or something. Plaintiff's name for many person is many person have everything. Alleged cause of action in the complaint filed in this action against the defendant name each. Defendant especially sure to remember defendant is many person name everybody. If one or two person not including this section, even judgment not, and then they don't have any name, in case they cannot take them out. Defendant's name, all of them, don't remember. To statutory covership allegation, covership. This action seeks possession of real property, that is, check only apply, resident or commercial. Normally house is resident, the business is commercial. If residential is checked, complete all remaining items that apply to the action. If only commercial is checked, no further items need to be completed except the signature and verification on page 2. This action is based in whole or in part on alleged default in payment of rent or other alleged charges, yes or no. 3. Statement regarding rental assistance required all action based on non-payment of rent or any other financial obligation. Please, no, plaintiffs must answer all the questions in this item, and if letters seeking a default judgment will also need to file verification regarding rental assistance. Unlawful detainer. 8. Has plaintiffs received rental assistance or other financial compensation from any other source corresponding to the amount demanded in the notice underlying in the complaint? Yes or no. B. Has plaintiffs received rental assistance or other financial compensation from any other source for rental according after the date of the notice underlying if the complaint, yes or no. C. Does plaintiffs have any pending application for rental assistance or other financial compensation from any other source corresponding to the amount demanded in the notice is underlying the complaint? Yes or no. T. Does plaintiffs have any pending application for rental assistance or other financial compensation from any other source for rental according after the date on the notice underline the complaint, yes or no. Next to page 12. 4. Are the allegation plaintiffs makes the following additional allegation? State an additional allegation below, with each allegation lettered in order, starting with A, B, C, F. If there is not enough space below, check the box below and use time MC025. Title, if attachment, and letter each allegation in order. Other allegations are on from MC-025. 5. Number of page attached, date, name, and signature. Verification, the same person. Use a different verification from in the verification is an attorney or for corporation or partnership. I'm the plaintiffs in this proceeding and have a right to plaintiff complaint. I declare the penalty of perjury under the laws of the state, California, that is foregoing is true and correct. 5 is on the top, is just a name and signature. In the bottom, verification, meaning oath. Oath. That's a different, same person in signature 2 times. Next one, page 13. This is cover sheet. Cover sheet is so important. On the top, case name is 17. Civil case cover sheet. Unlimited and limited. Unlimited meaning over $35,000. It's unlimited. Limited meaning complex case limited under $35,000 or less. Demand is $35,000 less, limited. Over $35,000, unlimited. Mark, that's the important. Over $35,000 is filing fee, $499. Limited cases, filing fee, $195. There's a different. Filing fee is different. Complex case designation, counter, joint, file with the first appearance by defendant, something. That one is, so you should remember that everything. Check one box below for the case types that best to describe this case. Auto-tote. Auto-tote meaning vehicle complex for the order. Uninsured motorist. I don't have any insurance. Mark here. Other PI, PW, WD, personal injury, property damage, wrongful death, something. Asbestos, product liability, medical malpractice. Other PI, PW, WD. PI, personal injury. PD, property damage. WD, wrongful death. Non-PI, PD, WD. Business tort, unlawful business practice. Civil right, defamation, fraud, intellectual property, professional negligence, other non-PIPWD, employment, didn't pay the salary or something, wrongful termination, other employment. Next, contract. Contract is normally business. Any lawsuit is the 90% is contract. Breach of contractive warrant, breach of contract. Rule 3.740, collections. Please pay the money. Other collection. Insurance coverage, other contract. Real property. Eminent domain, inverse. Condemnation. Wrongful eviction, other real property. Unlawful detainer meaning eviction. This section is unlawful detainer, eviction. You don't pay the rent, that is unlawful detainer. Commercial or residential, or drugs. Judicial review, assert, forfeiture, petition, re-arbitration award, writ of mandate, other judicial review, right side, provisionally complex civil litigation, antitrust, trade regulation, construction defect, mass tort, security litigation, environment, toxic tort, insurance coverage claim arising from the above listed enforcement of judgment, miscellaneous civil complaint, recall, other complaint, miscellaneous civil petition, partnership and cooperatives, governments, other petition. Number 2, this case is or is not complex under Rule 3.400 of the California Rules of Code. If the case is complex, mark the factors requiring exceptional judicial management. A. Large number of separately represented parties. This meaning is so many persons, just one person plaintiffs, one person defendant. No. Plaintiffs, one or two persons, but defendant is so many persons live in this house. In case there's a different. B. Extensive motion. Two. Extensive motion practice raising difficult or novel issue that will be time consuming to resolve. C. Substantial amount of documentary evidence. D. Large number of witnesses. E. Coordination with the related action pending in one or more courts in other countries, states, counties, or in a federal court. Substantial post-judgment judicial supervision. 3. Remedy sought. A. Monetary. B. Non-monetary declaration or injunctive relative relief to punitive monetary meaning for the involved money, didn't pay the rent or didn't pay any money. Non-monetary declaration of injunctive relative meaning, no, I don't want to request for the money, just sorry about that or something. Or punitive meaning, for example, the penalty, something. The number of cause of action, just normally just one. But sometimes one is monetary, another one is other action. This case is or is not class action suit. 6. If there are any known relative case, if and third notice of relative case, you may use from CM jury file, date and signature. Next page. Page 14. 14 meaning request for until default, club judgment or court judgment is if apply for the unlawful detainer, you should be out, and then the other party didn't answer. In case request for until default, club judgment or court judgment. Number 1. To the club on the complaint or cross-complaint filed on date, name, seat, and the default of judgment. Default judgment, name, this time is name meaning defendant's name. D, I request a court judgment on the Code of Civil Procedure section 585, B, 585, C, 989, X, against defendant's name. Defendant name. Testimony required applied to the club for a hearing date unless the court enter club's judgment. Even the other parties didn't pay the rent. E, enter club judgment. Number 1, full restitution of the premise only and each a read of its caution on the judgment Code of Civil Procedure section 1174C does not apply. Including in the judgment all tenants, subtenants, name, claims, and other occupants of the premise. You should mark here. The prejudgment claim of right to possession was served in compliance with Code of Civil Procedure section 415.46. 2. Under Code of Civil Procedure section 585A, complete the declaration under Code of Civil Procedure 855.5 on the reverse. 3. For defendant previously entered on date. 2. Judgment to be entered. Demand of complaint. All the money you didn't pay amount. Credit acknowledged. How much the credit? Nothing the credit. Demand of complaint. Statement of damaging. Special, general. Interest. Normally interest 1 month is 10%, 3 months is 30%. Cost. Attorney fee. Almost request for attorney. Total something. Attorney fee, attorney request for some money. Total something. Daily damage word demand complaint in the radar. Daily damage meaning, for example, $2,000 per month. In case daily damage, 30 days, one for 1 day normally $68. 68. Total, how much? G, daily damage word demand complaint at the rate of how much per day beginning. For example, that the 3 days ago, beginning date. 3, other, if filed in the unlawful detainer case, legal document assistance or unlawful detainer assistant information is on the reverse. Date, name, if this page payday, a clerk is signed in this paper, this is judgment. Judgment. Next page. Legal document assistance or unlawful detainer assistance. Legal document assistant or unlawful detainer assistant, the same meaning. If legal document assistant or unlawful detainer assistant did or did not compensation, give advice or assistance with this form. If declaration was received any help or advice for pay from a legal document assistant or unlawful detainer assistant, state. Assistant name, B, street address, city and zip code, C, telephone number, 4, D, county of registration, E, registration number, F, expire on. Number 5, declaration under Code Civil Procedure 585.5. This action, A, is or is not on a contract or instrument sale for goods or service subject to civil. B, is not on a conditional sale contract subject to civil code. C, is not on an obligation for goods, service, loans, or extension of credit subject to code civil procedure. 6, declaration of mailing. A copy of this request for entry for default was A, something not mailed to the following defendants whose address are unknown to plaintiffs or plaintiff's attorney. B. Mailed first class postage prepaid in a sealed envelope addressed to each defendant attorney of record. This meaning first class postage normally for reusing for the stamps envelope, white envelope. This is the first class mail. If none, to each defendant last known address as follows. Mailed on date, 2 names and address shown on the envelope, just reusing for the white envelope. That's it. 8, mailed on date, 2 specific names and address shown on the envelopes. I declare on the penalty of perjury under the laws of the state of California that the foregoing item 4, 5, and 6 are true and correct. Yeah, this is just an oath. Every time is oath and then name and signature. Memorandum of cost. Clerk's filing fee. Filing fee normally $3.95. Process service fee. Somebody delivering this document to the defendant. Normally they charge $100. Process service fee $100. Other total cost and disbursement and weight. I am the attorney, agent, or party and claim these costs to the best of my knowledge and believe this memorandum of costs is correct and these costs were necessary incurred in this case. Same thing, I declare on the penalty of perjury the laws of the state of California, that's the foregoing, and the 7 is true and correct. Everything is the same thing and correct. Name and signature. This is one more page. Next one. 8. Declaration of non-military status. Non-military status. I didn't go to the military. If military, we cannot go. We cannot unlawfully detain a reason for. They should move every time. As a number 8. Declaration of non-military status. No defendant, respondents named in item 1C is in the military service of the United States as defined by either the servicemen members. I know that no defendant respondents named in item 1C is in the U.S. military service because check only apply. If the other party is for the military, if all the paper is making, but the last page, number 8, wow, he is military, in case we cannot make this document. I know that no default defendant respondent's name item 1C is in the U.S. military service because check only apply. A. The search result that I received from say the defendant respondent is not in the U.S. military service. B. I'm in a regular communication with the defendant respondents and know that they are not in the U.S. military service. C. I received the contracted the defendant respondents and they told me that they are. Okay, page 17, unlawful detainer judgment. If you file for the unlawful detainer and then judgment apply for the by yourself. If not apply the judgment, no judgment. Any kind of judgment you should file by yourself. On the top, the same thing, attorney or party without attorney name and telephone number, email, and something. Superior Court of California, County of Los Angeles, address, plaintiffs and defendant. Judgment unlawful detainer by clock, by default. By default meaning the other party is no answer. After court trial, by court, possession only. Possession only meaning I don't want any, just return my house. That's possession only. Defendant did not appear at trial. Normally, judgment unlawful detainer by default. Number one, by default judgment, defendant was properly served with a copy of the summons and complaint. B. Defendant failed to answer the complaint or appear and defendant the action with the time allowed by law. 3. Defendant default was entered by the clerk upon plaintiff's application. D. Clerk judgment for possession only of the premises described on page 2, item 4. Just this is no money, doesn't matter. Just to return to my house, that's all. E. A court judgment, the court considered 1. Plaintiff's testimony and other evidence. 2. Plaintiff's or other written declaration and evidence. 2. After court trial. After court trial meaning the other party appeared to the court and the plaintiff and defendant appear to the court and they fight. This is after court trial. The jury was waived. They don't have any jury. The court considered of the evidence. A. The case was tried on date and time before named judicial officer. B. Appearance by plaintiff's attorney, somebody. Continued attachment to B. Defendant's attorney. Constitute of attachment to B. C. Defendant did not appear at trial. Defendant was properly served with notice of trial. B. Statement of declaration was requested. They do or not. Next page 18. Judgment is entered as followed by the court, the clerk. The court meaning judge is there. If not, just the clerk only. 3. parties' judgment is for plaintiffs, name each. Judgment is for plaintiffs, landlord, and against the defendant, name each. Continuing the attachment to be A, B, for defendant, name each. Defendant name all of them. 4. The defendant entitled to possession of the premises located at street address, apartment, each and county. Plaintiffs named in each item 3A. Defendant name in item 3B. Defendant list on attachment from UD 110P in item A, B, A1. 5. Judgment is applies to all occupants of the premise, including tenants, subtenants, if any, and name claimants, if any. 6. Amount and terms of judgment. 8. Defendant named in item 3A above must pay plaintiffs on the complaint. B. Plaintiffs is received nothing from defendant named in item 3B. Defendant named in item 3B is recover costs and attorney fee. Past due rent, number 1. Holdover damages, attorney fee, cost meaning filing fee or something. B. Other meaning for delivery fee, something. Total judgment, how much that? C. The rental agreement is cancelled. If you are a landlord, you can request for the cleaning fee. If the other party carry the dogs and cats, we need a special cleaning for the any smell, any cleaning, they can request it. C. The rental agreement is cancelled. Rental agreement they have, but from today that's cancelled. The lease is forfeited. 7. Conditional judgment. Conditional. Plaintiff has breached the agreement to provide habitable premises to defendant as stated in judgment. Unlawful detain the habitable premise attachment from UD 110H, which is attached. 8. Judgment for partial agreement, partial eviction. Partial eviction is issued Number 8, judgment for partial eviction. Partial eviction is issued stated in judgment, unlawful detainer, partial eviction, attachment, which is attached. 9, other. Contingent on attachment. 9, something. Date, judgment officer, judicial officer, judgment sign here. That's all. Normally stamp. This is judgment. If the judgment receiving within five days, they should be out. If not out after 5 days, marshal or sheriff come to that house and then they're gonna close the door. After that, they cannot move it at any material. After judgment within 5 days, they cannot move any material. Next one, page 19. If you are tenant before the judgment, if the other party filed for the court action, in case tenant is filed for the answer, that's so important. If not answer, within 5 days is finished. Within 5 days, before the 5 days, they can answer, they do. After 1 month, they do the judgment. If you didn't pay any rent, tenant, the landlord file for the summon. In case you should file within 5 days, you should file to the court. In case you should file for the court date, they do 1 more month, they leave. They can leave it 1 more month. Okay, on the top, everything is same. If you're receiving the unlawful detainer, tenant should file answer. Answer is important. If not answer, 5 days, marshal is come, you should be out. But if you have any answer, which is reason, no reason, doesn't matter. If you wanna answer, just answer fine, you can leave 1 more month. That's so important. Number 1, defendant, all defendant for whom this answer is filed must be named and must sign this answer unless their attorney sign. Normally, attorney or without attorney doesn't matter. Just a tenant, you can make this paper. You don't need any attorney. Defendant, all defendant for whom this answer is filed must be named and must sign this answer unless this attorney denial answer the complaint as follows. 2, denier check only one of the next 2 boxes. Just 1 box marked A, general denier. That's the good. General denier, no reason, but do not check this box if the complaint demands more than $1,000. You cannot sign here. Unlawful detainer more than $1,000. If the mark here just $1,000 less, defendant generally denier each statement of the complaint and the mandatory cover sheet and supplemental allegation unlawful detainer something. If you do not check this box, if the complaint demands more than $1,000, $1,000 over the $1,000, you cannot mark here. But how you can unlawful detainer amount is $1,000 less? That's impossible. Normally B, mark here. Specific denier, check this box. The complaint 1 and 2 below. If complaint demands more than $1,000, Defendant admit that all the statement of the complaint and of mandatory cover sheet and supplemental allegation unlawful detainer form UD 101 are true except if you receiving the unlawful detainer summon, everybody mark here. That's easy. On the top, your name and address or something. The second line is Superior Court of California, County of Los Angeles, court name and address. Court name and address, the other party, let know to put right here. That just mark the same thing. Plaintiff, same thing. Defendant, the same thing. Number one, defendant, your name here. Number two, everybody mark B, specific denial. And one, denial of allegation or complaint from UD 100 or other complaint for unlawful detainer. Defendant claims the following statement of the complaint are false. State paragraph numbers from the complaint or explains below, or if more than needed, on Form MC-125. To B, defendant has no information or belief that the following statement of the complaint are true. So defendant denies item, denied then, state paragraph number from the complaint or explain below, if more room needed, on item Form MC-025. Explanation on Form MC-025, title attachment 2B. The other one is just remember, one, denial allegation complaint. In case A, defendant names of following statement of the complaint are false. Explanation on Form MC-025, title attachment 2B. Just no reason why you didn't pay the rent. House is not clean. They didn't, not the cleaner. That's all. Or sometimes attachment, some animal is there. That's it. B, defendant has no information or belief that the following statement of the complaint are true. So defendant denies them. The other party says that you didn't pay the rent. That's all. 2, denial of allegation of mandatory cover sheet and the supplemental allegation. Unlawful detainer. A, defendant did not receive plaintiff's mandatory cover sheet and the supplemental allegation. If not checked, complete B and C as appropriate. B, defendant claims the following statement, mandatory cover sheet and the supplemental agreement. Unlawful detainer are false. State paragraph number from UD 101 or explain below. If more room needed, Form MC-025. Explanation is on the Form MC-025. Title as attachment 2B. Doesn't matter. Even you are wrong, doesn't matter. You can file. Next page. Page 20. 2B. Defendant has no information or belief that the following statement on mandatory cover sheet and the supplemental allegation unlawful detainer from UD 101 are true. So defendant denied them. State paragraph number from UD 101 explained below, or if more room needed on item MC025. Explanation on item MC025, title as attachment. Doesn't matter. B. Defendant and objection. Defendant is objection. Which one is objection? For each box checked, you must state, believe, brief fact to support. If in item 3T on page 3, or if more room is needed on form MC025, you can learn more about defendant and objection at www.coach.or.gov. 8. Non-payment of rent only. Plaintiffs had breached has warrant to provide habitual premises. Just mark here, it doesn't matter. This meaning plaintiffs has breached, has warrant. The warrant provide habitual premise. B. Non-payment rent only. Defendant made needed repair and property deduction the cost from the rent, and the plaintiffs did not give properly credit. Mark it here. I requested for some repair, and then he didn't do anything. It's okay. C. Non-payment of rent only. One date before the notice to pay or quit expired, meaning for the 3 days notice before the date, defendant offered the rent due, but plaintiffs would not accept it. How much are you gonna pay? And then plaintiffs didn't accept. No, you should pay all of them. Back here, doesn't matter. D. Non-payment of rent only. Plaintiffs' demand for possession is based on non-payment of rent due more than 1 year ago. E. Plaintiffs waive, change, cancellation notice to quit. F. Plaintiffs served defendant with a notice to quit or file complaint to rent retaliate against defendant. G. By serving defendant with the notice to quit or filing the complaint, plaintiffs arbitrarily discrimination against the defendant is violation of the Constitution of the laws of the United States of California. H. Plaintiffs' demand for possession violate the local rental control or eviction control ordinary of city and county 5 title to audience and date of purchase. Also brief state the item 3T the fact showing violation of the premises. I. Plaintiffs demanded the possession is subject to the Defendant Tenant Protection Act of 2019, Civil Code Section 1946.2 or 1947.12, and is not compliance with the action. Number one, plaintiffs fail to state the just cause termination of tenants in the written notice to terminate. B2, plaintiffs fail to provide opportunity to cure any alleged violation of each item and condition of the lease other than payment is rent required under Civil Code Action 1946.2c. 3. Plaintiffs fail to comply with the relocation assistance. 4. Plaintiffs has raised the rent more than the amount allowed under Civil Code Section 1947.12 and the only unpaid rent to the unauthorized amount. 5. Plaintiffs violate the Tenant Protection Act in the another manner the defendant the complaint. You can mark at any, doesn't matter. That's not important. You can mark at any, and then after 1 month is the court hearing. Even not appearance doesn't matter. Just you can get the date, 1 more month date. Even you didn't pay, and 1 more month leave there. That's, for example, if you paying to the $2,000 rent, just $300 paying to the court, and 1 more month you can leave it. That's the reason. J. Plaintiffs accepted rent from defendant cover period of time after the date notice to quit expired. K. Plaintiff seeks to evict defendant based on act against the defendant, defendant's immediate family member, or a member of the defendant household that constitute domestic violence, sexual assault, state stalking, human trafficking, abuse of the older or defendant adult, or a crime that caused bodily injury, involved a deadly weapon, or used to force or threat of force. This defendant requires one of the following, which may be included with the item: permanently, temporary restraining order, protective order, or police report that the more than 180 days act, a signed statement from a qualified third party, a doctor, domestic violence, of sexual assault, counselors, human trafficking, case worker, psychologist, or third party. Example: doctor, domestic violence or sexual assault counselors, human trafficking, cause workers, psychologists, or victim of violence, crime advocate, consummate, require injury or abuse resulting from these acts. Another form, if a victim, a document or evidence verifying that the abuse of violence occurred, Okay, mark here, doesn't matter. Number one, the abuse of violence was committed by a person who does not live in the dwelling unit. Two, the abuse or violence was committed by a person who lived the dwelling unit. Something. I. Plaintiff seeks no adequate defendant based on defendant or another person calling the police or emergency assistance. Example, ambulance by or on behalf of a victim of abuse, a victim or crime, or an individual on emergency, other defendant or the other person believed the assistance was necessary. And plaintiffs demand that the possession of a resident property of based on non-payment of rent only, other financial obligation, and check the only. Number one, plaintiffs received or has a pending application or rent assistance from a governmental rental assistance program or some other source relating to the amount claimed in the notice of the pay or rent or quit. Doesn't matter. Next to page 21. That's just to mark one or two. Doesn't matter. In case you can file, court is upset. Just you answer is accept, and then court date. You need not go to the court. Just answer a file, and 1 moment you can delete. That's the you have the right. 3 and 2. Plaintiffs received or has a pending application or rental assistance from a governmental rental assistance program or some other source for rental assistance. 3. Plaintiffs' demand of possession. Plaintiffs' demand of possession in based only the late fee for defendant failure to provide landlord payment within 15 days. The receiving governmental rental assistance. Doesn't matter, true or not. And plaintiffs violated the COVID-19. This time is not including COVID-19. Tenant received Relief Act and passed. O. The property is covered by the federal cares and the plaintiff did not provide a 30 days notice to vacate property covered in CARES Act means property where the landlord doesn't matter. This participation in a covered housing program as defined by the Violence Against Women Act is participating in the rural housing vouchers program under Section 542 of the Housing Act of 1949 or has a federally backed mortgage loan or federal, doesn't matter. P. Plaintiffs improperly applied payment. Improperly applied payment made by defendant in a tenancy that was existence between March 1st, 2020 and September 30, 2021, not including this one. Doesn't matter. This one is not including the past due, last time, COVID-19 period. This time is just that you don't need it. Q. Plaintiffs refused accepted payment from a third party for rental due, not including. Defendant has a disability and the plaintiffs refused provide reasonable accommodation that was requested. As other defendant defense objection of stating item 31st. F. Provide fact each either checked above, only below, or if more room needed, doesn't matter. 4. Other statement. Other statement is a defendant vacated premise on defendant. Doesn't matter. 5. Defendant's request that the plaintiffs take nothing request in the complaint. B. Cost incurred in this proceeding. C. Reasonable attorney fee. Mark here, doesn't matter. Next page. D. That plaintiffs be ordered, make repairs, and correct the conditions that constitute breach of the warrant to provide habitable premise and to reduce the monthly rent or a reasonable rental value until the conditional. E. Other facts below, doesn't matter. Number of page attached, doesn't matter. Unlawful detainer assistant. If you receive the unlawful detainer assistant, mark here, but the normally is not. Did not. And then name. Each defendant for whom this answer is filed must be named in item 1 and must sign this answer unless defendant's attorney fee. Just your name and then your husband or wife name here, sign. That's it. And then verification. Verification is just the oath. I am the defendant in this proceeding and have read the answer. I declare on the penalty of perjury under the laws of the state of California that the foregoing is true and correct. Your name or your husband, doesn't matter. Sign. That's all. This one is the unlawful detainer answer. If you receive the unlawful detainer lawsuit as possible, you had better unlawful detainer answer. If you file for the answer, you can leave 1 or 2 months more leave without any fee. That's so important as possible. Of course, if you have get any money, you had a better paying to the rent. If not, that's the problem. In case you had a better get the answer save the money. Sure to remember, unlawful detainer, you had a better fool. Not paying any answer. Okay, today finished. Here. You can go home.